Good afternoon, everyone. We will be starting momentarily. Judges logging on now.
Good afternoon, everyone.
Good afternoon, Your Honor.
Good afternoon, Your Honor.
Good afternoon.
Good afternoon, Your Honor.
Good afternoon.
Good afternoon, Your Honor.
Good afternoon. We're ready to start.
Yes, ma'am.
All right. Ladies and gentlemen, good afternoon. I am Judge Regina Mincy, and we're going to begin our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's Office has already accused these cases of the offenses brought against them, and the case has been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge, so we are able to address several matters, including bond, possible arraignment, and a possible plea offer if one has been made by the state at this juncture. I will also be providing you with a reset date for arraignment if it is not held today, and that date is, and for SAP, Ms. Holly.
October the 24th.
Right, October 24th. I want to begin by advising everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube, so govern yourselves accordingly. I want to also remind the defendants on this calendar that you have certain constitutional rights, the first being that you have a right to representation at this juncture in your case, and you should know who your attorneys are at this point. You also have the right to remain silent. Remember that anything that you state about the facts, the circumstances, or the occurrences of your case can and will be held against you. The solicitors or the prosecutors are here and they are listening, so listen to your attorneys. Who do we have first?
Good afternoon, Your Honor. This is ACDC. Before you is Ms. Dion Favors. And I forgot what position she is.
She's position 6. I represent her. I did request if we could go into a breakout room for her, and that is the only case that I need a breakout room for.
Well, I
right.
would recommend a signature bond, so I don't know if the breakout room is necessary.
Okay.
Oh. All right, let's keep it moving. Thank you, ASG Walker. I appreciate that. Let me call this case and then we'll hear from pretrial. I don't know if we need that either. 23 CR 00607 OB Dion Favors, charged with 1 count of theft of services. I understand that the state is recommending a signature bond. Do we need pretrial or you ready to
I'm ready with that. It's simple. She
Good.
received services at a hair salon located at 850 Oak Street in the West End Mall. She left without paying. The state is simply asking for $1,000 signature bond through the jail and to stay away from that salon located at 850 Oak Street.
Got it. All right. Anything else from the TD's office?
No,
Mrs.
we don't
Holland?
have any other issues with that. That's fine. Thank you.
All right, I will enter that $1,000 signature bond through the jail and a stay away from the hair salon at 850 Oak Drive in the West End. Also, I'm going to order Ms. Favors that there will be no drugs, no alcohol, no weapons, no guns while on bond, okay? Anything else?
Nothing from the state.
Nothing
Okay.
from the defense.
That's good.
Good afternoon, Judge Mincy.
Yes,
We're going to be starting here in courtroom 2 with position number 4, Ms. Crowder.
okay. 23 CR 00605-7Y. Vanessa Crowder, charged with 1 count of simple battery, 2nd count of theft of services. Pre-trial?
First arrest.
I'm sorry.
First arrest.
Okay, don't have your camera on, pre-trial. Go ahead, State.
Your Honor, this incident took place at the Juicy Crab located at 1715 Howell Mill Road in Atlanta. The defendant and a group of about 6 or 7 other individuals, they dined in at the incident location and received food and drinks. And when the bill came for approximately $259, the group got up and they tried to leave the facility. Words were exchanged between the victim in this case, whose name is Naomi, that's Niomi, last name is Jones, and she is on the Zoom call, Your Honor. Words were exchanged between the victim and the individuals, and then the defendant and another woman attacked the victim. They hit her in the head with a sign, and then they fled the scene. Your Honor, the state's recommendation in this case is a $4,000 surety bond. That's $2,000 on each count. No contact with the victim, a stay away from all Juicy Crab locations, 1-day anger awareness, and no drugs, alcohol, or weapons. And Your Honor, if you may sign for the victim when appropriate.
All right. Miss Naomi Jones. I think I see Miss Jones is signing in.
Good afternoon. Good afternoon, Your Honor.
All right, if you wish to address the court, I need you to have your camera on and I will swear you in first.
I actually don't have anything to say. I just wanted to be present to make sure that justice was being served.
Okay, all right, that is fine. Go ahead, PD Abden.
Thank you, Your Honor. My client is 22 years old. She was born in Georgia, has lived here her whole life. She graduated from high school. She's currently enrolled in school at Ultimate Medical Academy. She's pursuing her associate's degree in healthcare management. She's also gainfully employed. She works for a security company, and she has a 7-year-old child. She's the only person who can care for that child, Your Honor. My client firmly denies these allegations, and I am requesting a signature bond, Your Honor. This is her first arrest, and she understands her obligation to return to court, and has no objection to the stay away or a no further contact, Your Honor.
Okay. All right, I will order $4,000 signature bond through the jail. I'm going to order no further contact with the victim, Naomi Jones. I'm going to order Ms. Crowder to stay away from all Juicy Crab locations, and I believe there are quite a few in the Atlanta area, so Fulton County area. So she is not to go back to any of the Juicy Crab locations, not just the one on Howell Mill, but any location while she's on bond. I'm going to order no drugs, alcohol, weapons, or guns while on bond. And I will not order the anger management at this time. I'll save that for later.
Is that 2,000 on each charge?
Oh, yes. Sorry about that. Yes, 2,000 on each.
Thank you, Your Honor.
Mhm.
Judge, quick question. I
Yes.
have a Spanish interpreter case that's with Ms. McLeod. The name is gonna be Ronaldo Chavez. They're ready for courtroom 3, if we do have the Spanish interpreter available.
Do I see Ms. McLeod yet?
Good afternoon, Your Honor.
Oh, good afternoon. All right, if we could go to that one.
I haven't spoken with my client yet. No.
Uh-oh. Not so fast, huh?
Yes, because we didn't have the Spanish interpreter.
Interpreter, Judge.
We're gonna need a breakout room or something where I can speak with them.
All right, who's my Zoom master?
It's Miss
Okay.
Strong, but I don't see a Spanish interpreter on here yet.
I was
No.
informed, I have the other Spanish case. I was informed that both of their cases were being null processed.
Uh-oh.
Okay, well, I guess we won't need Spanish.
I'm not the state, so let them
I'm
confirm
sorry,
that.
what case is this?
This is Carlos and Ronaldo Chavez.
Yeah, they should be on the calendar, are they?
I don't see them on the calendar.
I don't either.
Correct.
Yeah, correct.
So they're not on because they're both being no pros.
That is correct, Your Honor.
Awesome.
Okay. All right, so that solves that problem.
Okay.
What do you have, Miss Holly?
Nothing, I'm just,
Do you
they're
have?
not on the calendar. I have not received the no pros, so when I do, so be it.
Just process them.
You'll
okay?
get it, Miss Ridgewater, I promise.
Thank you, Mr.
I'm not
Walker.
here today, so.
That's okay. Thank you.
All right, we'll keep moving right along.
This is gonna be position 10, Jenkins.
Okay.
No, I don't have a mention.
Hey, can you take on a call?
This is 23 CR 006062A. Mr. Jenkins is charged with 1 count of willful obstruction of a law enforcement officer and a 2nd count possession of marijuana less than an ounce. Pre-trial,
First arrest.
okay. State,
Your Honor, this position is actually a co-defendant with, I believe it's one of the add-on positions. Last name is Davis.
okay.
Your Honor, in this incident, the co-defendant, he was being arrested for possession of marijuana, criminal trespass, and disorderly conduct. Officers responded to MARTA located at 30 Alabama Street regarding a fight involving a weapon. And Your Honor, that's where the current defendant comes in. There was a weapon at the scene. There was a Taurus handgun, and this defendant took the handgun and fled the scene. So we are charging this defendant with obstruction for taking that handgun. The state's recommendation in this case is a $15,000 surety bond, a stay away from the incident location, no contact with the co-defendant, and no drugs, alcohol, or weapons.
All right, and the stay away, is that from all MARTA or just the what is that, the 5 points MARTA at 30 Alabama Street or?
Yes, Judge.
Okay. All right.
And I'm sorry, I forgot to add the fact of that there was marijuana found on the defendant's person, and that's where the possession of marijuana charge comes in. And for that charge, the state is recommending a $500 surety bond.
Okay. So a total of 15,500.
That's correct, Judge.
Okay. All right, PD Abden.
It's me, Your Honor.
Yeah.
Oh, I'm sorry. I
It's okay.
forgot that fast.
Your Honor, I'm representing the co-defendant. So if we want to
Oh.
do that one next, I just wanted to ask you if you wanted to do
Right,
that.
since the facts are the same.
Yeah.
All
Thank
right,
you.
go ahead, Ms. McLeod.
Your Honor, my client is 24 years old. As pretrial has stated, she has no record. She is gainfully employed and she has some college education, more than 2 years of college. She denies the allegations, Your Honor. She said she was with her friend and her friend just asked her to take a bag, which she took the bag. She did not know that there was anything in the bag. Based on that, Your Honor, I would ask the court to give my client a signature bond so she can get out of jail, get back to her work, because she is presumed innocent here, Your Honor. Nothing further.
All right. I'm going to order a $5,500 signature bond through the jail. I'm going to order for that, Ms. Bridgewater, and for everyone, that'll be 5,000 on the obstruction and 500 on the marijuana charge. With that, there will be no drugs, no alcohol, no weapons, no guns while on bond. There will be a stay away from the 5 Points MARTA station at 30 Alabama Street. There will also be no further contact with the co-defendant, and that is Deonico Davis. Anything else?
Yes, Your Honor. Just for the record, the state would like to place an objection on the record for a signature bond involving a handgun. As you know, it is a danger to our community involving handguns, so we would like to place that on the record. But we are respecting your ruling.
All right, thank you. I guess the biggest thing, ASG series, there's no gun charge. It's an obstruction charge. So I will take notice of your objection.
Yes, Your Honor. Thank you.
Thank you.
Thank you, Your Honor.
All right. Can we do Davis next, Deputy?
Davis,
All right, this is 23 CR 006074Y, Deonico Davis, charged with 1 count of possession of marijuana less than an ounce, 2nd count of criminal trespass, 3rd count of disorderly conduct. Pretrial?
Off cycles, last arrest 2018 for simple battery and criminal trespass. The simple battery was dismissed. The criminal trespass was a conviction. A 2017 disorderly conduct conviction, and then a 2016 2 counts of theft by taking conviction, and nothing further.
All right, thank you. State?
Yes, Your Honor. For position 5, in this case, the incident location was in on Cleveland Avenue and Sullivan Road. In
For
that
position,
Yeah.
hold on. I think we're doing Davis, the co-defendant case.
There
Oh,
are 2
sorry.
cases.
For
So
position, for add-on position 2, that is the co-defendant case.
Yeah.
So again, in this case, officers responded to a fight involving a weapon. The defendant was engaged in a fight with another person, and he was also seen jumping into the tracks of the incident location, which disrupted the operation of MARTA. Your Honor, the state's recommendation in this case is a $17,500 surety bond. That's $15,000 on the disorderly conduct, $1,000 on the criminal trespass, $500 on the marijuana, 1 day anger awareness, a stay away, and no drugs, alcohol, or weapons. And I may need to redo my math. 1 second.
Okay.
Your Honor, should I present or are we waiting for the recommendation?
Let me hear the recommendation first.
All right, not a problem.
Okay.
Thank you.
Mhm.
Your Honor, that's $16,500. That's $15,000 on the disorderly conduct, 1,000 on the criminal trespass, and 500 on the marijuana, where he did have marijuana in his possession.
All right, thank you. All right, PD Admin.
Thank you, Your Honor. My client is 28 years old. He was born in Georgia, has lived here his whole life. He graduated from high school. He did attend some college at Georgia State. He's currently gainfully employed at Rosie's Cafe as a maintenance director. He is recommended, Your Honor, and so I am requesting a signature bond. It's my understanding he has a MARTA suspension, so a stay away is not an issue, does not object to that, and a no further contact with the co-defendant would also not be an issue. My client does deny the allegations, and so I am requesting a signature bond, Your Honor, for him to return to work, and he understands his obligation to return to court. He is not a flight risk, and that is all. Thank you.
Okay. I'm going to order $6,500 surety bond, which will be 5,000 on the disorderly, 1,000 on the criminal trespass, 500 on the possession of marijuana. I'm going to order stay away from MARTA, even though there's already a suspension. No further contact with the co-defendant, Leoril Jenkins. No drugs, no guns, no alcohol, no weapons while on bond. And
Sorry.
I think that'll be it. Yes, counsel.
Your Honor, I am just, the co-defendant got a signature bond, and so I am requesting Your Honor reconsider and allow my client to have the same. It sounds like the facts are the same, and from the state's recitation of the facts, my client was not the one with the gun, according to the state. And so I am requesting that Your Honor reconsider and grant my client a signature bond. All the other conditions we have no objection to.
And just to clarify, the state is saying that there was a fight involving a weapon, and that appeared to be used by the defendant, or had it on his person. The co-defendant Jenkins then took the weapon from the incident location and left. So I just want to clarify that.
Thank you. And that is not my client, Your Honor. That is the co-defendant.
Right. I think the reason I treat them a little different, there were 5 cycles history on Mr. Davis.
Yeah, but he is recommended, and they were all from a while back, I believe. I can pull it up. Yeah, his last arrest, Your Honor, was in 2018, to my understanding, and it states here that he is recommended.
Is that what you have, ASG, sorry?
I do have his last arrest in 2018, but he, as you said, he does have a history, and those charges and convictions do include violence. I saw disorderly conduct in a battery that was null prost.
Battery was null prost, Your Honor, so.
And tell me again, make sure I'm clear. Mr. Davis had the gun and Mr. Jenkins removed it from the scene?
Correct, Judge. And I also want to state, he is on the calendar for a second case, and that case also involves violence. So we would ask that you keep your ruling as stated previously.
Well, Your Honor, we can discuss the allegations in that case once we get to it. I think it would only be fair that Mr. Davis gets the same treatment as his co-defendant in this particular case. And given the fact that he is recommended, he's gainfully employed and will be represented in this case, I am asking that Your Honor consider that and allow him to return to court to handle this case. At this time, these are just allegations, Your Honor.
Right. I do understand, and I understand when we have facts of weapons, it's hard to treat them the same when they're both not the same, meaning one has history, one doesn't. I understand it's 2018 now, and also he has an open case, obviously, even though he's still recommended, but he has
There is no open case, Your Honor.
the other charge, the other.
Oh,
open-
the other case. Yes, I apologize.
Yeah. So he's a little different, maybe slight versus major, but I do want to make sure he understands the seriousness of the acts with the gun involved. I'm going to, I don't necessarily say that because people are co-defendants that I treat them the same. I look at their history and the YALA factors and whether I, treat them the same is based on their history and their background. Because he's got a second case, and I think that date isn't it the same date or is it close in time?
It's close in time, Judge. It's about a month and a half before the current case at bar.
Yeah, those are the things that make me want to just treat him a little different in the sense of he's got more history, more going on, had the gun. So I'm going to stick to my $6,500 surety bond for Mr. Davis.
Judge, what's the breakdown? Because it's two, we got position 5 and also for position 2 on the add-on.
For position 2, the disorderly conduct, that's 5,000 surety. The criminal trespass, 1,000 surety. And the possession of marijuana, $500 surety. So that's a total $6,500. And I haven't heard the facts on the other case yet from Mr. Davis. But if you want us while he's sitting here, we can go to that other case, position 5.
Yes, Judge.
Okay.
So the total bond is 6,500 for position 2?
Yes, position 2, 6,500 surety, yes.
Thank you.
Okay.
Your Honor, this incident took place on Cleveland Avenue and Sullivan Road. The defendant, we don't have the full report yet. However, based on the warrant, the defendant was in a verbal confrontation with a bus driver, and he began to punch the driver's door, and it did put the driver in a fear of being harmed. The state's recommendation in this case is a $2,000 surety bond. That's $1,000 on each. 1-day anger awareness, and no drugs, alcohol, or weapons.
All right, PD Appen.
Thank you, Your Honor. As we've already discussed, my client already has the other case where he has got a pretty high surety bond. I do not believe that he's capable of making that bond, Your Honor. His indigency is a concern. He will be represented, as I've stated, so he's not a flight risk. He does have a valid address and he will return to court. These are his only 2 open cases, Your Honor. He's not been arrested since 2018 for a charge that was null prost. These are just allegations at this time, Your Honor, and so I am objecting to the anger awareness class, and he does maintain his innocence until proven guilty, Your Honor. And so I am asking for a signature bond on this case.
But he did not, well, with the simple assault with the bus driver, and I know we don't have the complete report. Did he actually make contact, just not the battery, just an assault?
Correct.
Of the bus driver?
There was no actual contact.
And he does deny the allegations, Your Honor. I did speak with him about this, so that is his position at this time.
Based on the facts or allegations rather in position 5, I will order a $2,000 signature bond through pretrial. I'm going to order the 1-day anger awareness course through pretrial. And I'm going to, that will be 1,000 on each charge, Ms. Bridgewater. So I'll give him a $2,000 SOB pretrial on position 5 with 1-day anger awareness course. No drugs, alcohol, weapons, or guns while on bond. And again, he's under a suspension from MARTA, which I guess will include bus and rail. So he's not to use MARTA. And that will be it.
Thank you, Judge.
Mhm.
Your Honor, can we do position 1 on the add-on calendar? We have a private attorney that's waiting. It's
Just getting ready to do that case now.
oh, thank you so
Understand.
much.
Come on, sir. This is position 1 on the add-on, Judge.
All right. Who's the private attorney?
I believe it's Attorney LaScala.
Judge Michael Escala.
Okay. All right, thank you. This is 23 CR 0060736. Is it Jose Cabrera Medrano? Charged with,
Correct.
excuse me, charged with 1 count of escape, custody confinement, and a 2nd count of battery family violence from September the 30th, 2023 pretrial.
6 cycles, last arrest, May of 2021, for interference with custody. There was no disposition listed. And then a 2021 possession of marijuana less than an ounce conviction, and nothing further.
Okay.
Sure. In this case, it happened on September 30th of this year. Law enforcement was dispatched to 4005 Wingate Way, where they spoke with the victim, Ms. Catherine Stanwyck. She advised that she was in an argument with the defendant where it turned physical. He choked her. The officer did observe bruising around Ms. Stanwyck's neck. He was taken into custody and transported to Northside Hospital, where he was to be medically cleared to be transported to the jail. At that time, he did slip out of his handcuffs and escape from custody. The state is asking for, there currently is a $10,000 total surety bond, $5,000 on each count. The state is asking for a $2,000 surety bond on the battery family violence and $1,000 on the escape, for a total of $3,000 total surety bond. No contact with the victim is Catherine Stanwyck. We have reached out to her. We were unable to make contact. And a stay away from the incident location, 4005 Wingate Way. No weapons, drugs, and alcohol while out on bond. That's it.
All right, Attorney LaScala.
Judge, all that's true. The only allegation, though, the only note that brings to the court's attention is I was actually retained by the victim's mother. This is apparently a mental health issue, and I'll work through with Mr. Walker. I would ask that there be no violent contacts and no contact. They may need to have contact with them, and I'll state as my place as an officer of the court that this is what the family's desire is.
You spoke to the victim's mother or the victim,
I spoke to the victim's mother.
but not the victim. I do have a little concern about that. I'll sound for the victim. I don't think the victim is on. Catherine, is it Stanwyck?
That is correct.
But
We
I'm a
reached
little
out, we're unable to contact her, so.
right. I'm a little concerned before ordering contact with the victim with having no interview of her.
I understand.
To her.
I could always do a consent order if they do reach out to her at a later time. That's not a big issue, Judge. I just want to bring it to the court's attention.
Okay. I will go with the state's. Do you have anything else to present, Mr. LaScala? I'm sorry.
Yeah, I spoke with Mr. Walker. I agree with all those terms.
Agree with that? Okay. So I will order the $3,000 surety bond, which is $2,000 on the battery, $1,000 on the escape. I will order stay away from 4005 Wingate Way. No further contact with the victim, Catherine Stanwyck. No drugs, alcohol, weapons, or guns while on bond. And I believe that's it. Did I leave out anything?
That's all the state had, Your Honor.
Okay. Anything else?
I don't
Mr.
think so.
LaScala? Okay. All right. That'll
Thank you, Your
conclude
Honor.
this case. Thank
No,
you.
Judge, thank you. Thank you, Mr. Walker.
Position 15, Sims.
Okay. This is 23 CR 006069G. I'm sorry, wrong case, 15. 23 CR 006056J. Shaquita Sims, charged with 1 count of criminal trespass. Pretrial?
3 prior cycles. Last
How
arrest
many?
was
I'm
three-
sorry,
3 prior.
3. Okay.
Last arrest was October of 2019 for forgery in the 3rd degree. That case completed in PTI and nothing further to add.
All right, State?
Yeah, sure. In this case, a law enforcement officer was dispatched to the AutoZone located at 1959 Metropolitan Parkway, where they spoke with employees at that location who advised the defendant became angry over her order not being processed correctly. The defendant became irate in the store, even went behind the cash register and was asked to leave. When she refused to leave, she eventually was taken into custody. The state is asking for $1,000 signature bond through pretrial services with the condition of a 1-day anger awareness class and a stay away from the incident location, 1959 Metropolitan Parkway, no weapons, drugs, or alcohol while out on bond.
All right, PD Kim?
Yes, Your Honor, we have no objection to signature on bond. However, we would like to request for through jail. She has to take care of 4 years old, mentally kind of challenged a child that she has to take care of. She's a single mother and she's working full time and also taking care of the child. She really has to go back to meet the medical needs of this child. That's all, Your Honor.
Okay, I will order a $2,000 signature bond through pretrial. I will order stay away from the AutoZone on Metropolitan. No drugs, alcohol, weapons, or guns while on bond. And that 1-day anger awareness course, which is free through pretrial, is what I also order. And I guess that should be it.
Thank you, Your Honor.
All right.
Position 11, Jones.
This is 23 CR 006054E. Quinetta Jones, charged with 1 count of criminal trespass. Pretrial?
17 cycles. Last arrest was July of this year out of DeKalb County for a failure to appear. 2 other FPAs from 2015, 2019. Criminal trespass conviction, 2015, 2019, 2023. A battery, family violence, battery, and disorderly conduct conviction in 2018. A simple battery and disorderly conduct conviction in 2020. And possession and use of drug-related objects conviction in 2022. And nothing further.
All right. State?
Your Honor, this incident took place at MARTA, located at 41 10th Street in Atlanta. This defendant has a permanent ban from MARTA, and on yesterday, she was seen at the incident location walking through the emergency train doors. As you've heard from pretrial, the defendant does have a history of FTAs, the latest one being this year out of DeKalb. So she does present a risk of flight. The state's recommendation in this case is a $1,000 surety bond, a stay away, and no drugs, alcohol, or weapons. Nothing further.
All right.
Yes, Your Honor. I spoke with Ms.
Holly?
Jones. She is 29 years old. She is disabled, so she would not be able to pay a surety bond because she does not work, but she does have a consistent address. It's the address that she gave to the court, 2796 Ward Lake Lane in Ellenwood. I would request that she be given a signature bond. We don't have any objection to any conditions.
Does she have any family or anything here in Georgia?
Yes, her cousin lives here in Georgia. And that's who she lives with.
All right, I will order a $2,000 signature bond through the jail. I will order to continue with the permanent ban from Marta. She's not supposed to be there at all. So that's a continual stay away and permanent ban. No drugs, alcohol, weapons, or guns while on bond. And I believe that's it.
Thank you, Your Honor.
Mhm.
Position 17, Thomas.
This is 23 CR 006063G, Brianna Thomas. Charged with one count of possession of a pistol or revolver by a person under 18 years of age, theft by receiving stolen property, and possession of marijuana less than an ounce. Pre-trial.
First arrest.
All right, state.
Yes, Your Honor. In this case, law enforcement officers made a traffic stop on a vehicle stopped at the intersection of Lakewood and Stillman Street. Upon making contact with the vehicle was running. The defendant was in the back seat of the vehicle, appeared to be asleep. There was a handgun located on the floorboard in the back seat next to the defendant. There was a second handgun in the front of the vehicle. Upon trying to wake the defendant, nearby individuals exited from a nearby home and made contact with the officer, advised that one of their mothers was the owner of the vehicle. At that time, the defendant did exit the car. The officer observed that one of the handguns that was located next to her person had been moved. In searching the vehicle, both weapons were ascertained. One of the handguns were identified as previously stolen. And at that time, she was taken into custody, possession of a firearm by someone less than 18 years old, theft by receiving, and that item was one of the handguns, and marijuana was located on her person. To the first count, the state is asking for a $15,000 surety bond. To the second count, the state is asking for another $15,000 surety bond. And to the charge of the marijuana, we are asking for a $1,000 signature bond through the jail. We're asking for no weapons, drugs, and/or alcohol.
All right. Ms. McLeod?
Yes, Your Honor. My client is only 17 years old. She's a high school student at Carver High School, she tells me, and she's never been in any trouble. She tells me she was fast asleep in our brother's car. She was actually in the back, I believe. She was just sleeping. She doesn't know anything about the guns or the marijuana or anything else in the car. She's just a child, Your Honor. She doesn't know, she was just sleeping. She said she was surprised when the police showed her. She was waiting for her brother, who I think she said had gone to see his girlfriend or something, and she was just in the car sleeping. I would ask the court to consider giving my client a signature bond. She doesn't work. She's a high school student. She's in no position to pay for a bond. I was able to contact her grandmother, who is willing to sign on her signature bond, Your Honor, but she doesn't have the money to pay for a bond. And she is presumed innocent, Your Honor, and her story makes sense that she was just sleeping in her older brother's car. Nothing further, Your Honor.
Your Honor, I'll just add that again, the car was running and was located in the intersection. And when the officer first made contact, there was a handgun located next to her. And when he went back to the vehicle, that handgun had been moved and she was trying to conceal the actual weapon. So she was doing more than just sleeping.
Your Honor, that is not what my client told me. She told me that the car was parked. She doesn't even drive.
I didn't say she was driving. I said she was located in the back seat of the car. The car was
That is right. She was sleeping.
And she tried to conceal the stolen handgun.
She was hard to wake up.
She was
She
hard to wake
denies
up.
that, Your Honor. She was just sleeping, waiting on her brother. in the car. She was not even driving. She's 17 years old.
Well, some 17-year-olds have a license.
I know, but she
Oh.
does not drive, Your Honor.
He does not drive. Okay. Pretrial,
Yes,
did you get the information? What's grandma's name? Since she needs a cosigner, she's 17.
Yes, Your Honor. Grandma's name is Veronica Reese. Reese, Veronica. And I have her on the telephone right now, Your Honor.
All right, and she needs to bring a utility bill.
I'll find out if she has one.
Okay.
Your Honor, grandma does not have a utility bill in her name.
Well, I hope she has an ID. Picture ID.
She does have ID, and she tells me that she works at Grady Hospital.
All right. I'm going to make this a signature bond, but I'm going to make it pretty high, so that if there are any violations, and she'll know what the consequences are. This will be a signature bond through the jail. I'm assuming grandma would keep in contact and have her back in court.
Yes, Your Honor.
And so the amount is going to be $5,000 on the pistol or revolver, the first charge. Theft by receiving stolen property, $5,000. And then possession of marijuana was $1,000. So that's $11,000.
That is correct.
Okay, thank you. $11,000 SOB jail. No drugs, alcohol, weapons, or guns while on bond. And I guess that's it. Anything else? I don't know that. Oh, let me order this. Let me order a curfew. And that curfew, usually, what do we do, Mr. Walker? I think
The high school, so yeah, I would say 8 p.m.
Okay.
Or 9, Your Honor, just out of an abundance of caution. Maybe she has extracurriculars, I don't know, but I don't think 9 is unreasonable. She's a 12th grade at Carver.
All right, I'll do 9 p.m. to 7 a.m. I don't know what time school starts for her or what time she gets out in the morning.
I would think maybe 6 or 6:30, Your Honor. They usually have to get to school pretty early.
All right, 9 p.m. to 6 a.m. So from 9 p.m. to 6 a.m., Ms. Thomas, you should be in the house. And also, I'm going to order that she continue to go to school, go to high school, and hopefully complete it or get her GED. But it
Yes,
sounds
I
like
think
she's
she
on
plans
track.
to. She's in the 12th grade and she plans to graduate high school, Your Honor.
All right, so I'm going to require that she attend. And I think that is it for now.
And grandma should go to pretrial to sign her bond.
Yes.
Could pretrial
But you
please?
said jail, is it pretrial?
No, it's through the jail, that's right.
I'm sorry, it's to the jail. I'm sorry.
Yes, so she
Correct.
would have to go to the jail.
And so she doesn't need to go, since it's through the jail, she still doesn't have to co-sign, correct?
I'm not sure, Your Honor, because she's 17, I don't know.
I was gonna ask that question too. I don't know, Mr. Walker, even though it's through the jail, does she still need a co-signer because she's 17 even?
I know you need a co-signer for pretrial. I don't know about if it's through the jail, Your Honor.
I don't either. I don't know
I
that I've,
don't, and I don't know either.
none of us know. Can someone enlighten us? Does
So they
anyone?
don't do co-signers through the jail, only through pretrial.
Okay,
Great.
thank
So
you.
she's able to sign then. Okay, that's awesome.
Well,
Thank you.
will she be able to sign herself out since she's 17?
I know, I still keep wondering about that.
I would ask this is done through pretrial services, Your Honor.
Yeah, she qualifies. Let me do per judge and order it through pretrial, just so that there can be the monitoring and grandma can go down and sign her out. I'd hate to find out tomorrow she's still there because she needed it.
That is true. That is true, Your Honor.
Yeah, and in abundance of caution and you know, she can be monitored with that curfew as well through pretrial. So tell grandma to go down and pretrial. I'm sorry, I'm gonna order it through you all.
Are you waiving the requirement for the utility bill?
Yes, I'll waive that requirement for the utility bill. Send me that waiver.
Grandma has ID.
But she does have ID. Good.
Could I have the address, Your Honor, so I can give to grandma for pretrial? I should have it, but I don't.
For the trailer at the jail?
Yes. Oh, so it's right at the jail. Okay.
Yeah, isn't the trailer right at the jail pretrial?
Okay.
Yes, it's right in the back where they bring the inmates.
Okay.
Yeah.
Okay. All right.
All
Thank
right,
you.
thank you.
And
All
that
right.
concludes my business before the court today. May I be excused?
Yes, you may. Thank you.
Thank you.
Position 9, James.
This is 23 CR 006060D. Stephen James, charged with 1 count of simple battery and a 2nd count of battery. Pretrial?
2 cycles, both out of Las Vegas, with the last being in 2019 for battery, and that case was dismissed. And nothing further.
All right. State?
Your Honor, this incident took place at Emory, located at 550 Peachtree Street in Atlanta. The defendant was a former patient at the incident location, and he had been discharged from any treatment. He then came back on the property, and without seeking any treatment, he went through an unauthorized entrance. And when the defendant was being escorted off the property by the hospital police, and the victims in this case, Kevin Singleton and Austin Freeman, he then punched both of them in the face. Officer Freeman sustained a bruise to his cheek. The state's recommendation in this case is a $5,000 surety bond. That's $3,000 on the battery and $2,000 on the simple battery. No further violent contact with the victims. MHET if appropriate, and no drugs, alcohol, or weapons.
All right, PD Abden.
Thank you, Your Honor. I did speak with my client. There are no MH concerns, and so we would object to the MH, the mental health evaluation. My client is 56 years old. He is currently in Georgia visiting his daughter and his grandchildren. He's originally from Louisiana, and he's currently living in Las Vegas. As I've said, he's temporarily staying here with his daughter in Georgia. And he does have a lot of family here as well, so he does have strong ties to the community. My client is not currently working due to his disability, and he is on SSI, and so he does receive a fixed income, and so he would not be able to afford any bond set today, Your Honor, and so I am requesting that Your Honor consider his disability and his indigency when setting bond today. He will be represented by our office. We do have good contact information for him, so he is not a flight risk and understands his obligation to return to court. He does deny the allegations, and he does not object to any stay away or no further contact with the complaining witnesses, Your Honor.
Okay.
And Your Honor, it seems that his daughter is on the line. She just wrote in the chat. I don't know if it would be helpful to hear from her, but I did not speak with her prior to this because I didn't have her phone number.
What's his daughter's name?
Brittany, I can speak with her, but it's my understanding that is the address in Georgia where he's staying, where he can also receive mail, but I do have another address for him as well. And his daughter does have children who are his grandchildren that he came here to visit, Your Honor.
Okay, I will order a $5,000 signature bond through pretrial. I'm going to, and that will be 2,000 on the simple battery, 3,000 on the battery. I'm going to order a stay away from Emory University Hospital. Since we do have other options, I sometimes will say unless treatment, but I don't want him going back due to the nature of the allegations. So if he needs any other medical attention, he needs to go to the other hospitals that we have in the city. I'm going to order no further contact with Kevin Singleton and Austin Freeman, the 2 officers at Emory. I'm going to order no drugs, alcohol, weapons, or guns while on bond. And I'm going to order the 1-day anger awareness course through pretrial. And I think that'll be it for now.
Thank you, Judge.
Honor.
All right.
You're done. You're done. Position 19, veto.
This is 23 CR 006065C. Jordan Vito charged with 1 count of cruelty to children in 3rd degree, 2nd count of battery, pretrial.
16 cycles, TAs 2013, 2006. A possession of a weapon conviction 2013. Possession or transport of a firearm by convicted felon or felony first offender conviction 2010. Willful obstruction, theft by receiving stolen property, criminal attempt, and criminal trespass conviction 2006. And then possession of a firearm conviction 2015. I'm so sorry, Judge. I was reading Walker, the one up under it. Let me start from the top. 16 cycles. Last arrest was October of 2022 for FPA. 2020 conviction for willful obstruction and theft by taking. 2018 conviction for possession of marijuana less than an ounce. 2017 conviction for possession or transport of a firearm by convicted felon, fleeing or attempting to elude. 2016 conviction for disorderly conduct. 2017 conviction for criminal trespass, and then a 2012 conviction for simple battery against a police dog or detention officer. And nothing further for veto.
Yes, Your Honor. In this case, law enforcement was dispatched to the incident location where they spoke with the victim, a Miss Alicia Garcia. She advised that she had came to that location to pick up her child from her boyfriend. Upon putting her child in the vehicle, the defendant came outside and grabbed her by the neck and drug her back inside of the home where he punched her several times. The officer did observe bruising around the neck area of the victim. This did occur in front of her 2-year-old child. The state is asking for a $3,500 surety bond to the 1 count of battery family violence, to the count of cruelty to children in the 3rd degree. We are asking for a $1,500 surety bond. This happened at the defendant's home, so we are not asking for a stay away. He is not the father of the child in question. We are asking for no contact with the victim, however, Miss Alicia Garcia, no weapons, drugs, and alcohol while out on bond. And of course, I would sound for the victim to see if she's on the line.
All right. Miss Alicia Garcia. Miss Garcia.
Hi, yes, ma'am.
Where are you?
I'm currently out of town at the moment. I was dealing with a family loss.
All right. If you wish to address the court, you must turn on your camera and I'll swear you in.
I really don't have anything to say other than that it's just a sad situation that happened, but he's a good person.
Stop, please. Like I said, if you want to address the court or say anything, you must turn on your camera. I must be able to see you and I would swear you in. Otherwise, there's nothing that I will allow you to say or comment on unless you're sworn in and I can see you. And I'm assuming that's a no. All right, go ahead, PB Kim.
Yes, Your Honor, my client is 28 years old. He was born in Louisiana and he has been here in Georgia. However, he worked at Henson Car Wash as a crew member. However, right now he is unemployed. Due to his unemployment, he is qualified for public defender services. He completed his GED and we would like to request for $1,000 maximum bond for both charges, $500 each. Thank you.
All right, I'm going to order the $5,000 surety bond. It's $3,500 on the battery and $1,500 on the cruelty. I'm going to order no further contact with the victim, Alicia Garcia. I'm going to order no drugs, alcohol, weapons, or guns while on bond. And I think that'll be it.
Your Honor, right now there is $1,500 for each charge already preset. And he is also having a hold on foreign county, so he has to be released to another county. I was wondering if we can at least keep the same rate.
Okay, I don't know that I knew that. I can do it at the 3,000 surety bond, 1,500 on each.
Thank you, Your Honor.
All right. You have that, Ms. Bridgewater?
Yes, ma'am, I have it. 1,500 on each.
Thank you.
You're welcome.
No, they want 15% on each bond.
And Ms. Garcia, you're unmuted. We can hear you talking.
Oh, I apologize.
Uh-huh.
Question, Judge. Mr. Vito said he was interviewed by Ms. McLeod, not Ms. Kim, so.
Oh, is there a conflict?
He was a conflict.
Not anymore, Your Honor. Actually, there was, we identified different complaining witness. So I sent out an email that he is no longer conflict, that I will be representing him.
Okay.
Thank you, Ms. Kim.
No problem. Thank you.
All right, you're done. Yes.
Another question?
Yes. Go ahead.
Excuse me, Judge.
I'll be happy to interview you, or I'll be happy to answer all your questions. Please give me a call back.
Yeah, I was just trying to let you know that the lady that I talked to, she told me something different. I never talked to you, so I never got a chance to let you know exactly what happened with the case. And that the victim, the so-called victim, her name, that's not her real name, is not Alicia Garcia. That's not her last name.
Okay, that is something that your attorney can address. The only question I would answer for you at this point is if you had any questions regarding your bond condition.
Yes, ma'am. That's another thing I'm telling my judge. I won't be able.
This is not your trial. This is just a bond hearing.
No.
And bond hearing doesn't, my bond ruling does not necessarily have anything to do with the name of the victim. I listened to the allegations that are from the warrant, and that can be sorted out by your attorney as far as the victim's correct name and any other issues regarding that. But I'm sure that PD Kim knows what to do in regard to that. And that may be something that will have to be taken up later in your case. But right now, that's not necessarily indicative of my decision regarding your bond. It's more so based on your 16 cycles, your criminal history.
No, I apologize, Judge.
Call me. I will address all the issues. Please call me.
Okay, so when would I be able to call?
Yeah, the jail officer knows my number. They can redirect you.
So can I let the judge know that I'm actually injured right now. I done been in a car accident and I got 9 holes in my leg. And so I'm not working right now. So that's why I was explaining to the other lady that I talked to that I wouldn't be able to pay no bond at this time. I don't even have no job. I'm not even stable right now.
I already addressed that information to the judge. Mr. Vito, please call me.
When?
Position 20, Mr. Walton.
This is 23 CR 006067J. Tony Walton, charged with 1 count of simple battery, family violence, a 2nd count of willful obstruction, the law enforcement officer, 3rd count of criminal trespass and damage to property. Pretrial.
16 cycles, 2 FTAs, 2013, 2006, a 2006 conviction for criminal attempt, criminal trespass, willful obstruction, theft by receiving stolen property, a 2010 conviction for possession or transport of a firearm by a convicted felon or felony first offender, and possession of marijuana less than an ounce, a 2013 conviction for possession of a weapon that was out of Florida, out of Kentucky, and then a 2015 conviction for possession of a firearm out of Kentucky, and nothing further.
Okay.
Yes, Your Honor. In this case, law enforcement officers were dispatched to the incident location where they spoke with the victim and Ms. Lakeisha Sanders. She advised that her and the defendant lived together and they were engaged in a verbal disagreement, at which time he became physical. He did push her into a wall. After that, he went outside and I believe broke the window out of her car and flattened her tires. Upon arriving at the location, the defendant did run from officers. The state is asking for a $2,000 surety bond to the 1 count of simple battery family violence, a $1,000 surety bond to the 1 count of obstruction, and a $1,000 surety bond to the 1 count of criminal trespass. We are asking for no contact with the victim, Ms. Lakeisha Sanders, and we are also asking for a stay away from the incident location, 3640 South Fulton Avenue in Hateville. No weapons, drugs, or alcohol while out on bond.
All right. PD Kim.
Yes, I was wondering if we could talk to the complaining witness, and yet because I could not contact her, and yet they are working together, Your Honor, at Airport Rental Company. The complaining witness is actually his boss, and they work together, they live together. So if he gets ordered to stay away from her, he has to lose both housing and employment. So we were wondering if we can talk to the complaining witness. And yet he also has 2 biological children with her. So they're twins, 13 years old, that he has to take care of financially. So we would like to request for signature on bond to return to work and his financial support for children. Otherwise, we would like to request for a maximum $1,000 good bond, Your Honor. He is going to be qualified for public defender services if he has to stay away from the workplace. Thank you, Your Honor.
All right, I'm going to order the $4,000 surety bond, $2,000 on the simple battery, $1,000 on the obstruction, and $1,000 on the criminal trespass. I'm going to order stay away from the incident location. Must find somewhere else to live temporarily while on bond. No further contact with the victim, Lakeisha Sanders. And no drugs, alcohol, weapons, or guns while on bond. Anything else?
Could we sound for Miss Lakeisha Sender if she's online?
Yes, Lakeisha Sanders. Lakeisha Sanders. Think I see anyone on by that name. All right. There's nothing further, $4,000 surety bond.
Thank you, Your Honor.
Mhm.
Position 18, Ulyss.
This is 23 CR 006071E. Eric Ulyss, charged with one count of giving false name, address, the birth date to law enforcement, and simple assault. And then a simple battery, all three charges. Pre-trial?
56 cycles. Last arrest was September of 2022 for driving while license suspended or revoked. He's currently on or appears to be on probation for burglary. That's out of Fulton County from February of 2019, 8 years probation. 4 FPAs, 2012, 2016, 2 in 2019. Terroristic threats conviction, 2019. Willful obstruction conviction, 2014. Theft by shoplifting conviction, 2014. Criminal trespass and fleeing or attempting to elude a police officer conviction in 2011. Burglary convictions in 2005. A 2004 conviction for interference with government property by receiving and entering auto. A 2003 conviction for theft by taking. And then a 2001 and 1993 conviction for theft by receiving stolen property. And nothing further.
Yeah, sure, Hunter. In this case, law enforcement was dispatched to the Rainbow Clothing Store located at 2064 Campbellton Road, where they spoke to the store manager, Miss Alicia Mack. She advised the defendant came into the store in an aggressive manner, causing a scene. She advised to the defendant if he was not making a purchase, he would need to leave. At that time, the defendant pulled out what appeared to be a silver and color handgun and pointed at Miss Mack and another store associate by the name of Jamisha Winbush, and told them that I will pop you B words. At that time, the defendant was finally agreed to leave the scene. Law enforcement officers were dispatched. They were able to locate the defendant nearby to the store. Search incident to arrest revealed that the handgun that he had on his person was a replica gun. He also gave a false name to the officer of DeMarcus Thurman. And speaking with the store manager, she advised that this is not the first time that he has came to the store and caused the scene, and this is not the first time they had to call the police on this defendant. To the one count of false name, the state is asking for $1,000 surety. To the 2 counts of simple assault, we are asking for a $15,000 surety on each count. In total, that's a $31,000 surety bond. A stay away from the Rainbow Clothing Store, 2064 Campbellton Road, and no contact with Miss Alicia Mack and Miss Jamisha Winbush. No weapons, drugs, and or alcohol. We have referred this case to the DA's office, and we are waiting to hear back for the felony transfer.
All right, PD Kim.
Yes, Your Honor. My client is 53 years old, Your Honor. He has a grown-up children, 5 of them, and he also has 6 grandchildren. He's gainfully employed, doing owned business cleaning services. However, his income is very low because of slow business. He's qualified for public defender services. And Your Honor, there was only one charge this morning about giving false information, and surprisingly, there were 2 more charges added on. He does not have any funds to pay for this bond. So considering his indigency, we would like to request for signature on bond. And if not, if Your Honor is not inclined to give him a signature on bond, we would like to request for maximum $1,000 for each charge, even that he may have a very hard time to pay for. Thank you, Your Honor.
All right. I'm gonna order surety bond. with that amount, on the first charge of giving a false name, $1,000 surety bond. And on the 2 counts of simple assault, 5,000 each. So that will be $11,000 surety bond. And stay away from the Rainbow Store, 2064 Campbellton Road. No further contact with Alicia Mack. And no drugs, alcohol, weapons, or guns while on bond.
Your Honor, the second victim's name was Jamisha Wimbush.
Oh, thank you. And Jamisha Wimbush.
And that store is located inside of a shopping plaza. Can the defendant be ordered to stay away from that entire plaza? As I said, I spoke with the store manager and she's very fearful for her life. They were unaware that was a replica gun, so she was under the impression that she was going to lose her life that day.
Right, to stay away from the whole plaza there on Campbellton Road. And I think that's it. Okay,
He has a question, Judge.
yes.
Mr. Ulis, please give me a call if you have any questions. You have a right to remain silent. Anything you say will be used against you. I strongly recommend you stay silent. Give me a call back, please.
Are these felonies?
The judge already made a ruling, please. If you have any question, call me, please.
Position 16, Straub.
Below.
Twenty-three CR 006059E, Brian Straub, charged with 1 count of battery family violence, pretrial.
For a moment, please.
Okay.
It showed 2 cycles, with the last arrest being from 2002 out of Alabama for possession of a forged instrument. And that was a guilty conviction and nothing further.
Yes, Sheriff. In this case, law enforcement was dispatched to the extended stay hotel located at 1050 Hammond Drive, where they spoke to the victim, Mr. Eric Sykes. I do see that Mr. Sykes is on the line. He advised that him and the defender are in a relationship and they live where they're currently staying at that hotel. They were engaged in a verbal altercation that turned physical. The officer did observe bruises and scratch marks on Mr. Sykes' person. The defendant is charged with 1 count of battery family violence. We are asking for a $3,000 surety bond. No further contact with the victim and to stay away from the incident location. We will sound for the victim, Eric Sykes.
All right. Mr. Sykes, I believe I've seen on the line. Mr. Sykes, do you wish to address the court?
Yes, ma'am.
All right, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
You don't mind, I need you to take off your hoodie or take off the hood part anyway. Yes,
Yes,
all right,
I apologize.
okay. All right, what would you like to say to the court today?
I would like to say to the court that he's not a threat. We did get into a verbal altercation and did get physical, but it wasn't to where like we was trying to hurt each other or anything like that. I didn't even know that they set out a warrant or anything like that because me personally and him both told the officers that it was just one of those nights. Like we had, to be honest, we overindulged in alcohol and one thing just led to another, but it wasn't as bad as for him to stay away from me or nothing like that. Cause I don't feel like I'll be harmed by him. I don't feel threatened by him or nothing like that, Your Honor.
And so at this location, 1050 Hammond Drive or whatever, whose place is that?
I'm sorry, that at the extended stay we stay in?
Oh, that was extended stay?
Yes, ma'am.
And both of you were staying in that location or that room?
Yes, ma'am.
Was it in a certain person's name or you just both pay it?
No, we both paid.
And is it in one name versus the other, or is it in both names?
It's in his name.
His name? Okay.
Yes, ma'am.
All right, any cross-examination?
Not from the state, Your Honor.
All right, go ahead, PD Kim.
Yes, Your Honor. I would like to request for a no for the violent contact. This happened on August 15, 2023, Your Honor. He was born in 1976 and he has been working. However, his DoorDash business has not been doing well. So he is qualified for public defender services. And he used to have a house which he lost. That's why they are staying at extended stay, Your Honor. They have been together for 2 years and they have not had any other issues. So we would like to request for signature on bond since this is his first arrest in terms of violence. So there is no other case. So we would like to request for signature on bond and no further violent contact. Thank you.
All right. I will order the $3,000 signature bond through pretrial per judge. I'm gonna order right now to, I guess, as far as the cooling down, there should have been a cooling down period. And so the victim, Mr. Sykes, you want no further violent contact with Mr. Straub?
Yes, ma'am. Like, whoa. What does that mean first? Can you explain that to me?
No further violent contact. You
Yeah.
have contact, but it can't be violent.
Yeah, okay. Well, yes, ma'am.
Okay. Since this happened in August and we're now in October, I assume it's all over and there won't be any need for any future cases, correct?
Yes, ma'am, you're correct.
Okay, so I'm going to order no further violent contact with the victim. I'm going to order no drugs, alcohol, weapons, or guns while on bond. And since it's through pretrial, I'm going to have them take the 1-day anger awareness course. All right, so 3,000 SOB pretrial.
So, Your Honor, can I say something?
Yes.
Will he be getting out today?
In 24 hours or so.
Oh, okay. Is it possible that I can come up there and pick at the county and pick up his belongings that he was arrested with?
Well, I assume they're going to give them to him when he gets out, aren't they?
Yeah, but if he got to wait 24 hours, then I might as well go
It's
up there and
up
get him
to
myself.
24 hours. He would have to sign a property release, and they're not going to do that when they're getting ready to release him.
Okay, that makes sense.
Yeah, so he'll get his belongings,
Okay.
whatever they checked him in with.
Okay, no further questions, Your Honor. Thank you.
All right, thank you.
Judge, I do have a quick announcement. There's 2 people that has not been on our calendar. And I'm not sure if there's another add-on, and they have not also been all crossed. The first one is Ricardo Elibert. And then the second one is Barry Duperon.
Hold on a second. Let's see what the state said.
Let me check.
Spell that second name, Barry.
Barry Duperon is spelled D-U-P-E-R-O-N.
All right, state, do we have any information?
In 1 second. So Ricardo Ricardo, that's going to be an NOD. That's why it's not on the calendar. And then Duperon, Ms. Sorry, was that your case? I forget.
Yes, it is. It was accused. I'm just trying to pull it up.
Okay.
So Elibert is an NOD, okay.
Correct.
Yes, he's been accused. 23 CR 006 072E.
Don't have him on the add-on or on the calendar. Do we know why that is?
I have no idea, and I'm also showing Cedric Rucker as NOD.
That's that was already accused, so that's going to be a null prize.
Okay.
Is that not the one I sent you
Oh,
already?
it's say NOD on the calendar.
Ms. Bishwa, did I not send you Cedric Rucker's null prize already?
Hold on, you probably did.
Yeah, that's the one you responded to.
Okay. I have so much paperwork you've been sending me.
Oh.
It's all about love. That's it.
That's right. That's right.
Yes, I do have Cedric Rucker.
Okay, and then the others will be NODs, so I'll make sure I'll CC you on that email.
Thank you.
And so we still don't know Barry Duperon. I see his mother in the chat. And then I see another person. So what are we doing on Duperon?
The state is ready. I mean, it's Ms. Sar's case, but the state is ready. He has to be handled because we don't want any Riverside issues, and the state is ready.
That's correct.
I did speak with him, Your Honor, and I'm also ready to proceed if we just add it to the calendar.
All right, you're gonna have to give some numbers to Ms. Bridgewater because it's not on the add-on.
I have the case number is 23 CR 006 072 E is in Edward.
Okay.
And spell the first name is Barry, B-E-R-R-Y.
BARRY.
I apologize. Is he not on the add-on calendar? Because under the case number, it says add-on. I'm just asking.
No, I don't. Well, the one that I have only had 2 names on it.
I do show, was he on the pool sheet? Maybe he was on the pool sheet.
He's on the pull sheet, and when you pull up his case number, Ms. Holly, it says it has him as an add-on. I just don't know if it was added to the add-on calendar that you all have, but he's on the calendar.
He wasn't added to the add-on calendar. But he's a battery family violence?
That's correct.
Okay, yeah, he wasn't on the add-on calendar, but we'll add him. There's no problem.
Spell the last name.
That we are missing?
Is it D-U-P-E-R-O-N?
Yes.
And it's 1 count of battery family violence?
That's what I show.
Okay.
That's correct.
All right.
Your Honor, this incident took place at 2814 Fairburn Road in Atlanta. Officers were dispatched to the incident location regarding the dispute. The victim in this case, whose name is Jason, common spelling, last name is the same as the defendant. The victim.
Hold on 1 second, Ms. Surya.
Are we doing Duperon's? I'm sorry, doing Duperon's case now?
Yeah, I think we assumed that was him. I apologize. We did not know. So in the chair now, we have Mr. Duperon.
Yes, that is correct, Judge.
Okay, sorry about that.
No problem.
Okay, go ahead.
Can I start over, Judge?
I think we have it. Just
Okay.
say victim, Jason.
Yes, Jason Duperon. He told officers that he was asleep when the defendant came home, woke him up, and began punching him several times in the face. The victim sustained swelling and a laceration to his eye and stated he did not know why the defendant attacked him. He was simply sleeping. We did speak with the victim in this case. He informed our office that he was not in fear of the defendant and he is okay with contact. The victim stated he does live at the incident location and the defendant does not. So the state is recommending a $3,000 SOB through pretrial given no history that we show. no further violent contact with the victim, and no drugs, alcohol, or weapons.
All right,
And I'm sorry, Judge, a 1-day anger awareness course.
all right. And we didn't ask pre-trial, but you said that you had no history. All right, PD Abden.
Thank you, Your Honor. My client is 29 years old, born in Georgia, has lived here his whole life, graduated from high school, and has an associate's degree in construction management. He's currently employed as a plumber's apprentice, and he hopes to get a job in that field after he is done with his apprenticeship, but he is not getting paid for that job, Your Honor. So on the side, he is doing DoorDash, and he's receiving assistance from his family. I am requesting a signature bond, Your Honor. It is his first arrest, as you've heard. To my understanding, he does not live at the incident location. That is his parents' home, and where his brother resides. It appears his family is on the line. I'm not sure if they're seeking to speak today, Your Honor, but it is my understanding that his brother does suffer from MH, and the incident, as alleged, was him trying to basically assist his brother with an episode that he was having at the time. As you've heard, his brother is not afraid of him, and I am requesting a no further violent contact, that he be allowed to return to his parents' home due to the circumstances, Your Honor.
All right, so I see in the chat, Ms. Terry Duperon, the mother, and witness to both involved, Barry Duperon and Jason Duperon, they're brothers. And then I see another person, Teresita Boozer.
And Judge, if we could sound for the actual victim in this case, please.
Right, and our actual victim is Jason Duperon, correct?
That's correct.
Okay, is Mr. Duperon on? Jason Duperon, is he on? Because I don't, he's not, okay. And so I don't know that I want to speak to the mother or whoever Miss Boozer is. Miss Boozer is can't read your lips, ma'am.
I have his mother's name as Terry, but with the same last name, so maybe that is her. I'm not sure.
Her? Teresita Boozer is Terry Duperon. Okay. All right. I am least getting that from her. Ma'am, the victim in this case is Jason, and I'm sure you would have a lot to add as the mother of the two of them. I think I have enough facts to make a decision at this point, or enough allegations anyway. So I would like to move on and give my ruling, because I don't know that there's anything that you're going to add that's going to probably change our mind or change the decision on bond. This is only a bond hearing, not the trial. Okay. All right. Thank you. All right. I'm going to order the $3,000 signature bond through pretrial. I'm going to order the 1-day anger awareness course. I'm going to order no further violent contact with the victim and the defendant. I'm going to order no drugs, alcohol, weapons, or guns while on bond. And I think that's it. Anything else?
That is all. Thank you, Your Honor. And Ms. Dupron, I'm going to send you my number. If you have any questions, feel free to call me after court.
Nothing from the state, Judge.
All right.
You're done. Position 1, Bailey.
This is 23 CR 006066C. I have 6 counts. First count, simple battery, disorderly conduct, willful obstruction of a law enforcement officer, simple battery against a police officer, police dog or corrections officer, willful obstruction, a second count, and second count, simple battery against a police officer. Pre-trial?
3 cycles, all out of Kentucky, with the last being in 2010 for disregarding a stop sign and DUI. The stop sign was dismissed. The DUI was a guilty plea. 1 FPA 2009 out of Kentucky, and then a 2009 alcohol intoxication in a public place conviction out of Kentucky. And nothing further.
All right, state.
Your Honor, this incident took place at the Ritz-Carlton located at 181 Peachtree Street in Atlanta. The defendant was at the incident location drunk and belligerent, and he was arguing with patrons of the establishment. The defendant was being escorted out due to his behavior, but he came back inside and slapped one of the security officers, whose name is Jordan Arnold. Once police officers got on the scene, they tried to calm down the defendant, but he would not, and he spewed racial slurs to the officers, specifically calling them the N-word. One officer was Officer R. Tate, and the other was Sergeant Durant. They both attempted to arrest the defendant, in which he resisted. He actually bit Officer Tate on 2 separate occasions and told them that they were not treating a white man how they were supposed to. Your Honor, the state's recommendation in this case is an $8,000 surety bond. That's $2,000 on each simple battery charge, $500 on each obstruction charge, $1,000 on the disorderly, a stay away from the incident location, no contact with the victims or the witness in this case, whose name is Deron, last name Tentyon, a 1-day anger awareness, no drugs, alcohol, or weapons.
All right. Is this PD Abden's case?
Yes, Your Honor, thank you. My client is 34 years old. He's originally from Tennessee. He was visiting Atlanta this weekend to go to the Braves game. So he does not reside here, but he does have ties to the community. He lives pretty close by. And so he understands his obligation to return to court. So he is not a flight risk. He did serve in the military, in the Marine Corps, as doing infantry, and he was also a demo expert. And he does have his associate's degree. He is gainfully employed. He works maintenance. He's been doing that since June 5th. And so the longer he does remain in jail here in Atlanta, Your Honor, the longer he will lose his job. He does have 2 kids, a 2-year-old and a 9-year-old. Those children are dependent on my client for child support, which is automatically deducted from his check. And so if he does lose his job, his financial obligation to those children would be harmed, Your Honor. I do understand that the allegations are alarming, Your Honor, but this is not his sentencing just yet. And so he is presumed innocent until proven guilty. And so I am requesting that Your Honor consider giving my client a signature bond, and he would not object to the stay away and no further contact. And if Your Honor is not inclined, at least a reduced bond, as I believe it was $8,000 was requested, and he cannot afford that at this time.
And so answer me this, what are his ties to Georgia?
He tells me that he came here to see friends and to go to the Braves game. He also qualifies for services, Your Honor, and so we will be representing him in this case. We have a good phone number, address, and everything of that sort for him.
But all of that is in Tennessee.
Yes, Your Honor.
So we don't have a contact or anything for him for Georgia, because he's going to be going back to Tennessee.
Yes, Your Honor. But as I've stated, he does understand his obligation to return to court. we do have a phone number, an email, an address for him. And he is not a flight risk at this time, Your Honor, and Tennessee is pretty close by. And so just like how he got here very easily for the weekend, he can also return to court.
And we have an FTA in 09 and a 2010 DUI.
And Judge, we also have a public drunk conviction stated by pretrial back in, I think it was 2009. So it seems that he's done this before. So he presents a risk of reoffending.
13 years ago, Your Honor. He's not been arrested since 2010, is my understanding as well.
But the 2010 was the DUI conviction involved alcohol, which is the same of what we have now.
It appears to be the case, Your Honor. And as a condition, we would not object at all to no drugs, alcohol, and weapons in the meantime, and to allow him to come back to court and deal with this case.
Right. I am alarmed by the allegations and main allegations with the law enforcement as well as the security officers at the hotel. Seems like he must have been pretty out of control a little bit. And so I want to make sure that he does come back, since he does have an FTA. And with this surety bond the state has recommended an $8,000 surety bond, correct?
Yeah, Your Honor. And
That's correct, Judge.
That is granted, he will remain in jail until SAP cannot afford that bond, and will also lose his job.
10 or 20%.
Yep.
Well, generally when I have people that are from out of state, no contact, and have history, similar history, I'm not inclined to give a signature bond just because of that, to make sure that they understand the importance of returning and that we're able to reach him to return. If he had better contacts with Georgia's sister, brother, someone that he had here. And I see he's raising his hand. I don't know.
Yeah, Your Honor, can we maybe ask him that? Because that, to my knowledge, I don't know.
And Judge, I'm sorry, Judge. I would also like to state that I understand you are considering giving him a bond regarding his answer. However, I would like to also make you aware that despite the victims in this case being called the N-word, they did try to calm him down. They tried to escort him off the property. So these charges would not have been brought against him had he not continued to be belligerent in public.
Right. And Your Honor, as you know, these are allegations at this time. These are not facts and should not be treated as such. This is not his sentencing or his trial, and he will come back to court and handle all of this at a later date. And it is my position that he is not a flight risk, and I would like to know from him if he does have any contacts here.
Okay.
Yes, I do. My father, Billy Manders, lives in Macon, Georgia. I don't have a physical address for him as well. But just for just to show the court, like, I have a biracial daughter, and like what I did that night doesn't prevent you from doing that. But
I'm not really hearing what he said beyond father lives in Macon. There was something else.
He did want to make the court aware that he has a biracial daughter and that he shouldn't be saying the things that that the allegations had alleged.
Okay.
But it sounds like he does have a father here in Georgia and Macon. And like I said, I have all the contact information for him, so I can reach out to him hopefully when he does get out and get his father's information and share it with the court if the court is inclined.
All right. I was hoping it was Atlanta. It's 2 hours away. I'm going to order a a $6,000 surety bond. And with that $6,000 surety bond, that's 2,000 on the 2 simple batteries. And the
Judge
simple-
had 3 simple batteries.
oh, I'm sorry, it's 3. So the 2 simple batteries on the police officers, that will be 2,000, so that's 4. And then on the other simple battery, that's 1,000, which is 5. And then on the, I'm gonna be out, it's gonna be 6,500, then 500 on the disorderly, the willful, and right, so it'll be 6,500. Did I add that up right?
Let me make sure I'm getting this right. Okay. On the simple battery, the first simple battery, what are we doing with that?
1,000.
Okay, we're gonna do a 1,000 on that one. Let's go straight down then. On the disorderly, is that a 500?
Correct.
Okay. On the willful obstruction, 500?
Yes.
On the simple battery against a police officer, dog, or otherwise?
2.
2,000? Okay, the willful obstruction again, 500?
Correct.
And then the other one, simple battery against a police officer, whatever, 2,000.
Correct.
Okay. All righty.
So that's 6,500.
It is, let's see, 1, that's 2, that's 4, that's 6,500.
All right, 6,500 surety bond, no drugs, alcohol, weapons, or guns while on bond. And that will be it for now.
Your Honor, we're asking for a stay away from the Ritz.
Oh, that's right. Stay away from the Ritz-Carlton. Actually stay away from any Ritz-Carlton. I think we have a couple in the Atlanta area.
And
So
Your
stay
Honor-
away from all Ritz-Carlton properties. And no further contact with the victims in this case, the security officers and the police officers. And the witness. And I've already said no alcohol, so we need to abstain from alcohol while on bond.
Thank you, Your Honor.
Thank you.
Position number 3, Colquitt.
And Your Honor, I'm requesting that we do this in a breakout room or at least save it till the end of the calendar for my client's safety.
Correct. Yeah, let's do that one last.
Thank you.
Position number 2, Brown.
Okay. 23 CR 006053F. William Brown, charged with 1 count of criminal trespass. Pre-trial.
Oh, sorry, before you start, just to save you some time, this is a PAD case and he has been accepted to PAD. I don't know if the Honor still wants to hear
Did he
the,
decline it?
so he did, and then he spoke with PAD and accepted, and they've accepted him into the program, is my understanding.
Are they coming to get him tomorrow or when?
Yes, Your Honor.
Tuesday? All right, go ahead, pre-trial, and then I'll hear from ASG Siri.
72 cycles.
How many?
I'm gonna count 72.
Your connection is horrible, Ms. Roberts. Start over again. I'm getting every other word.
72.
7 and 2.
Correct.
Okay. Just give me the last couple or so.
5 FTAs this year, 2022, 2021, 2019, 2017. Disorderly conduct, 2013. 2023. 2 open Alabama cases, both for theft by shoplifting, 2023 and 2022. He has a lot of arrests out of Alabama, but none of them have dispositions. They're all criminal trespass, shoplifting cases. And the next conviction that I was able to see was 2007 out of Florida for grand theft.
Okay. No Georgia history.
No more Georgia history, no. No recent, just a 23 disorderly conduct.
Okay. Okay. All right. ASG, sorry.
And Judge, I don't know if you heard, but that was a 2021 disorderly conduct conviction out of Georgia. I have a 2022 driving while license suspended conviction out of Georgia and a 2023 FTA here in Georgia. This incident took place at Grady, located at 80 Jesse Hill Junior Drive. Your Honor, this defendant was seen wandering around the parking lot and getting inside of a vehicle that was owned by Grady. When officers arrived, the defendant was inside of the van and had broken a window to gain entry. Being that this defendant has been accepted into PAD, the state's recommendation is a $1,000 SOB, a stay away, and no drugs, alcohol, or weapons.
All right. PD Appen.
No objection to that, Your Honor.
All right. So I will order that $1,000 signature bond through, I think we usually say the jail, only to be released to PAD.
Yes,
PAD
Your
will be
Honor.
there to pick
That's
him up
correct.
tomorrow.
It's a PAD representative.
All right, PAD representative will be there to pick him up tomorrow, so he should only be released to them. No drugs, alcohol, weapons, or guns while on bond. A stay away from Grady Hospital unless he's receiving treatment, since this did not involve treatment. And if he's not getting treatment, he shouldn't be on the property. I guess that's it. No drugs, alcohol, weapons, or guns while on bond.
Thank you, Your Honor. And one of us will submit a consent order. We're just trying to find out who should do that.
Okay, right.
Thank you.
Position 8, Jackson.
Okay. This is 23 CR 006061E, Elford Jackson, charged with 1 count of simple battery family violence. Pre-trial.
21 cycles. Last arrest, June of 2015 for driving while license suspended or revoked. A 2007 conviction for simple assault, willful obstruction, simple battery family violence. A 2005 conviction for cruelty in the first and criminal damage to property. A 2005 conviction for willful obstruction and simple battery. 98 criminal trespass, 89 robbery, and 91 armed robbery and robbery. And nothing further.
All right, state.
Your Honor, this incident took place at 1749 Emerald Avenue in Atlanta. Officers responded and spoke with the victim in this case, whose name is Connie. That's CONNIE. Last name is Copeland. She is the defendant's 72-year-old mother. She told officers that the defendant came to her residence in a state of intoxication. He got upset with her and started arguing with her, and then he beat her with a back scratcher. The victim did inform officers that she was in fear of the defendant. Given the defendant's history, as you've heard from pretrial regarding his history of violence, he does present a risk of reoffending. And because he is the victim's son, he does present a risk of intimidating the victim. The state's recommendation in this case is a $3,000 surety bond, no contact with the victim, a stay away, 1-day anger awareness, and no drugs, alcohol, or weapons.
All right. PD Holly.
Yes, Your Honor. Mr. Jackson is 55 years old. His last arrest was in 2015, and I believe that was just for driving on a suspended license. The last arrest of significance was in 2007, so that is over 16 years ago. Mr. Jackson is disabled. He had pretty serious hip surgery about 8 years ago, so he is not currently working. He does have 2 grown children. he does deny the allegations as the state has alleged them. We are requesting, based on the fact that he has no history at all in the last 10 years, other than a driving offense, that he be given a $3,000 signature bond. And he is not a risk-free offending. He does live in the area of Georgia.
All right, and he's from Georgia, lives in Georgia,
That's correct.
but does he live with his mother or he doesn't?
I don't believe they live together. This happened at the Emerald Avenue address, which is the address that he gave me. But Mr. Jackson, you don't live with your mother, do you?
No, ma'am.
I didn't think so.
But who lives at this Emerald Avenue address?
That's her address, right?
Yes, that's my mother address.
And Judge, if we may sound for the victim.
Right, Miss Connie Copeland. Connie Copeland. But PD Holly, does he have a separate address?
Mr. Jackson, do you have a different address than the Emerald Avenue?
Yes, ma'am.
Okay. Do you want him to put that on the record? Because we have it, is that all right with the court?
ASG, sorry, do you have an address on the record that's different from the Emerald Avenue? Maybe we should. Let's see, she's looking.
Yeah, I'm checking. I have the same address as the incident location.
Okay, let's have him put. Mr. Jackson, can you put your address that's not the Emerald Avenue address? Can you tell that to us, please?
No, it is the address.
That's what we just asked.
Yes, we both live there, but
You do live there or you do not live there?
Well, I don't live there no more.
Where are you going to be living later?
I guess I'm gonna stay at my father's house.
What's that address?
I don't know about her.
Does he also live in Georgia?
Yes, ma'am.
Does he live in Atlanta?
Yes, ma'am. He live in Fulton County. He live up County Drive.
I don't know if we
He
have
does,
it.
he does
Go ahead.
qualify for our services, Your Honor. So if the court's inclined to give him a signature bond, I do have his cell phone number, or not his cell phone number, I have his email. So as soon as he gets out of custody, I can get in touch with him and update the address, help him update the address for the court records once we have his dad's address.
All right. I'm just going to order the $3,000 surety bond. I'm going to order stay away from 1749 Emerald Avenue. You're not to go back there, Mr. Jackson. I'm going to order no further contact with your mom, Connie Copeland, while you're still on bond. No drugs, no alcohol, no weapons, no guns, while on bond.
Yes, ma'am. Your Honor, I got an SOB?
No, it is not. It is a surety bond. You go through a bonding company.
Well, I don't have no money to afford the surety bond.
Yeah, I'm a little concerned about the contact for you,
It
as
won't be
well
no call.
as well as the allegations.
There
that
will
I'm
no-
hearing.
there will be no contact, Your Honor, I promise.
Yep, I understand. Let's see
Mr.
what we can
Jackson,
find out
Mr.
first.
Jackson, we'll come see you in a little bit and get your dad's number so we can get an updated address for you, okay?
Yes, ma'am.
All right, thank you.
Position 7, Humphrey.
'23 CR 006058G, Daniel Humphreys, charged with 1 count of battery family violence, pretrial.
12 cycles. Last arrest was December of 2022 for simple battery and disorderly conduct. There's no disposition listed for that case. Appears to be on probation out of the tab for obstruction and forgery in the first degree. That is from December of 2018, and it was a 5-year probation sentence. And nothing further.
Okay. State.
Yes, Your Honor. This incident took place at 65 Irby Avenue in Atlanta. A friend of the victim in this case, whose name is Kayla Blades, that's Kayla Blades, common spelling. She called 911 to report that the victim was being beat up by the defendant. When officers arrived, they took a report and documented the victim's injuries. When the detective spoke with the victim, she stated that the defendant came over to the incident location and he was visiting their son. The defendant wasn't happy because the victim had her friend there and he wanted that friend to leave. And when the victim did not ask her friend to leave, he grabbed her by the neck, began punching her in the face, and she sustained a bloody mouth as well as swelling to her face. Your Honor, our office did get in contact with the victim. It does appear that she is recanting her story, stating that he never pushed her down, never struck her. However, I would like to point out that a friend actually called 911, not the victim herself. So the friend's testimony is more believable than this victim. Also, Your Honor, the defendant has an open simple battery family violence case with this very same victim. He was given a $7,000 SOB through the jail, ordered to have no contact with her. That case number is 22CR008521G. So he is in violation of that no contact order. He does present a risk of reoffending as well as intimidating the victim. The state's recommendation in this case is a $5,000 surety bond. Again, no contact with the victim, a stay away, 6-week anger management course, and no drugs, alcohol, or weapons.
All right. PD Holly?
Yes, Your Honor. And I do believe that the victim may be on, so I would ask to sound for her, but I can argue first.
Let's see. The victim is it Kayla Bronze?
I believe Kayla is the friend who called, not the victim.
Oh, the victim, tell me the victim's name again, sorry.
The victim's name is Kayla Blades.
Oh, okay. I put that as the friend, the name of the friend. Okay.
Okay, Kayla Blades. Kayla Blades, don't think she's on.
Okay.
All right.
Mr. Humphrey is 26 years old. They do share a 1-year-old son together, and they have been co-parenting through a third party. They have had no incidents since this happened. This incident allegedly took place in April. So it has been some time since this allegedly occurred. As the state said, Ms. Blades has retracted her statement, and the friend who called admitted that her and the defendant do not have a good relationship. So he does deny the allegations, and I think that the friend, it seems like, has reason to have a story separating her friend and my client. With all that being said, Mr. Humphrey is currently he's working on getting into an IT program so that he can become gainfully employed. He is doing an online course. He lives with his mother, and we are requesting that because he's not currently employed, he be given a signature bond for this case.
I'm going to order the $5,000 surety bond. I'm going to order no drugs, alcohol, weapons, or guns while on bond. I'm going to order at this time no further contact with the victim, Kayla Blades, or the witness. Give me the witness's name.
Your Honor, we don't have the full report.
Oh, okay.
I'll check, but I'll report back to the court.
Okay, so no further contact with the victim or the witness. Stay away from 65 Irby Avenue. And if there's visitation that is allowed with the child, that be conducted by a third party. And no drugs, alcohol, weapons, or guns while on bond. And he needs to stay 200 yards away from her. from the victim and no third-party contact, no emails, no phone calls, no texts, no contact in any form or by any third party.
And Judge, I'm sorry, do you have that report? So I have the witness's name.
I do not.
I said I have it.
Oh, you do. I'm sorry.
Yes.
Yeah, go ahead.
First name is F as in Frank, Ontina. Last name is Danile.
So it looks like Fontina Denial, Daniel,
That appears to be right, Judge.
something like that. Okay. All right, no further contact with either of them. That should conclude this matter. There's a question about your bond conditions, Mr. Humphrey. If not, this is just a bond hearing. It's
Yes.
not your trial.
Yes,
What's
Your
your
Honor.
question?
Ms. Kayla Blaze is active in the Zoom. If you can instruct her on how to talk.
She is in well, I sounded for her.
678 number. She's right.
Oh, this 678 number, 357-1315, Ms. Blades, Kayla. Can you hear me? The state should get that number for the victim and they will reach out and talk to her and explain to her as well. Thank you for that information. She may have stepped away.
This is our last case, Judge, position 3, Colquitt.
Okay. This is the one where we need the
breakout.
Yeah,
As
'cause
you
there's
know, we
still
can do
some
the
people in
breakout,
the
but I'm
courtroom.
still putting the facts on the record, so.
There are 2 other defendants still in the courtroom.
And Your Honor, I just, for the
Yes.
sake of my client's safety, I'm just requesting that at least the courtroom is clear if Your Honor is not inclined to take this in a breakout room due to the allegations.
You guys go ahead.
I think they're getting ready to clear the others out.
Thank you, Your Honor.
Did y'all want me to stop the live or am I still going? Ms. Abden,
Yes.
I know y'all didn't want to go into the breakout room, but did you all want to stop? Are you all requesting that I stop the live or do you, I don't know what to tell
And
you.
I'm objecting to that we stop the live because the live is our record, and without a live recording, we do not have a record as there's no court reporter present.
We'll still have the recording. We
Just the
usually stop the streaming
Oh,
until.
well, I'm objecting to that as well because there's an open court requirement. Without streaming to YouTube, the court would then be considered closed, and that's improper. So just as the public can view and attend any other court proceeding in Fulton County, it also applies to first appearances. So that's why we live stream. So we're in accordance with the Open Court Act.
And I understand the requirement of live streaming, Your Honor, but the fact that it's being saved and then being able to access it later on YouTube, easily searchable, is far beyond the open court and requirements that are imposed per the magistrate court rules. It is my understanding it's rule, I think it's 15.2. And so I do object to that, Your Honor, for my client's safety. That's going to live on the internet forever. These are allegations that are pretty serious. And so I am requesting that if we can please shut off the recording at a minimum. Thank you.
So again, without the recording, we want to have a court transcript.
No, not shut off the recording, you mean shut off the live stream.
Well, if we shut off the recording, we won't have a transcript, and we shut off the live stream, we won't be in compliance with the open court requirements. So as far as it being posted to YouTube, that's something separate.
I was only inquiring about the YouTube, Mr. Walker, not the actual recording, but y'all just
Right,
let
so
me
I'm
know what you
objecting
all would
to
like me to do.
us not live streaming, because if we stop the live stream with YouTube, we won't be in compliance with the open court requirement.
And as you're aware, ASG Walker, the things that go on at the jail, and so I would not want to subject my client to put him in harm's way just to put this on the record. And so I am still objecting to that, but I do understand your reasoning.
And I understand, and that's why we cleared the courtroom. There's no inmates. And again, if we shut off the live stream, we won't be in compliance with the open court requirement. It essentially would be a closed hearing, which is not permissible.
Well, if that is the case, I'm gonna go into the breakout. You know, whichever way you guys want me to do it, I'll go in the breakout or I'll cut off the live stream. And then I'm not going to allow the state to put the facts on live stream to put the defendant in jeopardy in the Fulton County Jail for the fact.
So it's my understanding that we can live stream, but we don't have to upload, or we can remove the upload from YouTube. So we need to live stream so it be compliance with the open court record requirement. And then the recording can be accessible for a transcript, but we can limit the public's access from YouTube after the court hearing is over.
Mr. Jordan there.
Practically speaking, I think that would be really difficult because it's one
It
video,
It is.
but it's whatever the court's inclined. I'm just very
Right,
concerned for my
so
client's
they
safety.
don't have
That's
to-
all.
It's one video, and I don't think Mr. Jordan has the capability to
Yeah, because the videos don't last forever on YouTube. They
Oh.
don't permanently stay on YouTube. No, you can go to the Fulton County YouTube page right now. We do not have, it only is up there for a short period of time. You can go to our YouTube page
but
right
that
now.
short period of time can put him in jeopardy, that little short period of time. So I'm very concerned about that.
Okay, well, the state has placed its objection on the record, and the reasons why, if we close off the live stream, it won't be an open court proceeding. And if we don't record it, we won't have a transcript as to what happened today.
I didn't say I wasn't going to record it.
Okay.
I said I wasn't going to
So
live stream it.
if we cut off the live stream, it essentially would be a closed court proceeding.
And so if I go into the breakout
I
and we
think that's
discuss
best.
the facts in there, we'll do that. And then when we come back, I can give my ruling, but I'm not going to allow the specific facts to be live streamed. They can.
Well,
we can
we've
talk
had
about-
several conversations, and I've been given a directive by my boss that I have to put the facts on the record. This just came up last week, and the simple remedy was that we cleared the courtroom. I'm not going to put excessive facts. I mean, it's a public indecency. It's
No, I totally understand that, and I'm not trying to be difficult at all. It's just the nature of the allegations are different than what we usually see. And I don't want to elaborate on that further. And so that's why I'm asking that if we could just please, for this one, for the safety of my client, go into a breakout room.
okay. Well, again, I've been given the directive that I have to put the facts onto the record.
So it's up to the
public
court to rule, I
the public
guess.
has the right to know and have access to this hearing because it is a court hearing, and all court proceedings have to be public. And
Right,
we
but
stop
if
the
the
live stream.
public is not present, then they need to go out and pay for the court transcript and then get it that way. And so I'm not objecting necessarily to you putting some facts on the record, but the facts that may put my client in jeopardy is what I'm concerned with. And so that's why I'm just
So
asking.
we're concerned that
it's
the
easier
inmates
to
are
go into a
watching,
breakout room.
because your concern was his safety in the jail. So we're concerned that the inmates are watching the live stream from jail.
No, it's twofold. It's the live stream and just the fact that it's going to live on the internet forever and he could be put
I
in
mean,
harm's way.
unfortunately, when you're charged with a crime, it lives on the internet forever. You can Google this defendant, and I'm sure you can find in the public records what he's
Mr.
charged with.
Jordan there? Mr. Jordan's there?
Let me go.
Thank you.
I mean, once you're charged with something and arrested for something, it's forever in the public domain.
I'm not trying to be
Yes,
difficult. I hear
I'm
you.
not, I know.
I
I'm not
hear
taking
you.
it personal. I'm just stating my position. The reason behind my position, I get that this is not the most savory charge, but unfortunately, once you're arrested and booked into the jail, it's public record. So it's always going to be in the public domain. We live in the internet era.
As you know, it's public record to an extent, right? you would have to go out and request certain
I'm
things
sure
and pay
you
for
can Google
certain
someone
things.
right now and pull up their mugshot and their charges. So I mean, beyond that extent, I
Yeah.
don't know.
You can pull up the
Everyone
mugshot
had,
and
I mean,
charges.
everyone who has
Not
been
to my
arrested.
understanding, Your Honor. I did not know that.
Well, you can go to the jail's website and or the sheriff's and do that. But the facts, the particular facts are what I'm concerned about getting out at this point. You can pull up the mugshot, you can pull up the charge. It's not going to give you the facts. It's not going to give you the allegations. When you look someone up on the jail booking screen.
So again, we had the same issue last week. I think Judge Law was sitting on the bench, and the simple remedy was we cleared the courtroom. We did not go into a breakout room. We didn't, this state was not limited in what it could or could not say on the record. I mean, you would never limit the defense on what they could or could not say in representing their client. So I think it would be prejudiced to the state as we represent the citizens of Fulton County, and then be prejudicial and improper. I get that he's charged with a crime that's not so savory, but again, it is public record. It needs to be live streamed because otherwise it would be a closed hearing, which is not permissible. The courtroom is clear. There are no other inmates there.
I just don't see how this is any different than any other, MH situation where we request a breakout room and we do it that way out of respect and for the safety of everyone.
Judge, I've just gotten Mr. Jordan, so he gonna.
What's the point?
Would you all please? Well, Judge, you asked for him, so I'm gonna let you.
Right, Mr. Jordan. You don't have the ability, I know, to cut, paste, and chop what's put out there in the public purview for our streaming. And we have a public indecency case. We have cleared the courtroom. And I understand last week Judge Law may have only done that, but not normally we have been stopping the live stream, but still recording.
Yes.
And so that's what I understood the policy to be. But Mr. Walker is correct that it would violate the open court requirement if we stop live streaming. And I just didn't know what you were able to do in that regard or what had been done about that.
That's up to you, Judge. We don't go with whatever the judge says to do.
I knew he was going to say that.
Pay some of the hearing or whatever.
Can't. So it's a stream, and we don't go back and edit the live stream. We just leave it exactly like it was. So we don't go back and edit anything after it's done.
So answer me this, Michael. So I'm sorry, Mr. Jordan. So is it only out there for a certain amount of time and then it's taken down?
So the YouTube stream, I'm not sure what. I think it's set up for 30 days.
Mm-hmm.
So after 30 days, the current video will disappear out there, but we still have it under our account. So we can always go back and view the video.
We can, but what about the public?
As far as the public, I think it comes off after 30 days.
Okay, so it's a 30-day cycle because I've been on there, Mr. Walker, too, and all these court dates obviously are not still streaming or able to even be accessed. And if it's a 30-day window, I am concerned about the safety, but I also understand about the open court requirement as well. And that, the public be able to view if they so choose want to do that. So we've cleared the courtroom. Let's go forward.
I just want to note my objection on the record, Your Honor, and of course we will proceed. It's just that per the rule that I had cited, the magistrate court rule, the public is given notice by virtue of this being held virtually. That is my understanding. And so that does meet that requirement. If anybody who needed to be here today, who needed to hear all of this, that they would be here today and did receive notice, Your Honor. So that is why I'm going to continue my objection, but the court has ruled. I just wanted to note that for the record.
And just to be clear, so your issue is the posting of the video to the YouTube platform, because that will allow people to access it tomorrow, today, or for the
Exactly. Correct.
So
Well, hold on, just to clarify, there are two issues. One being that it's going to live there for 30 days, and two, that there may be other people in the courtroom who might hear that, and that would be a danger to my client. That's been resolved, but the other one has not.
Right. And
Well,
I
the
don't have a
30 days
position.
has always been there. That's nothing new for today. I think that's what Mr. Walker is going to say too. The 30 days has always been there. There's nothing different. We were just, we have in the past shut down the streaming. And I think that's where Mr. Walker is saying that he objects to the shutting down of the streaming, even though the streaming is going to be there 30 days.
Right, because I
So
really don't
we
have a
have
position to it being posted on the YouTube page, but
Yeah.
I do have a position of the live stream being shut down. So
Okay, we're gonna go forward, PD
All right.
admin, both of them, and I'm gonna look at some of the rules and regulations. Because we didn't ever get our other thing resolved.
I am
either.
waiting for somebody from my office to let
Nobody
me
from their
know.
office has answered their other homework assignment, because what PD oh gosh, her last name, Debbie
Melnick.
Melnick was not, that didn't answer the question. It wasn't responsive to that.
Well, I didn't follow up on that, but just the following day, we had the same issue. A consent bond was issued, and it had conditions of a stay away and no contact, and that was actually consented to by Mr. Howard. But I just,
Right.
let it go.
Well,
But-
and I think you can do conditions. I'm still of that mindset because we have not found anything that said you couldn't. So if it doesn't say you can't, then you can until you tell me that I can't.
Right,
And
because
so
I don't think the
I would
conditions.
get- yeah.
I don't think
Go
the
ahead.
conditions would be punitive, because the conditions are not what's keeping the person in jail. It's
No.
the bond or the lack of bond. But it's just
Right. So all right, PDs, I'm putting y'all on. Tell Mr.
I just
Howard
wanted to
I-
let you know, I did do my homework. I'm waiting for Miss Melnick, PD Melnick, to review it. I did
Okay.
find some stuff, but I just wanted her to look at it first, and I will share it with both of you when I find it.
Okay. Okay, that'll be great. And if you could add this to her homework, and she'll say, what's the judge doing? Giving me more homework, add this to it. So that maybe you can do one email to us. to-
Absolutely,
this
but it
what-
is, it's magistrate court rule 15.21, I think, is what it is.
Okay, and
But
I'll look at that as well.
yeah, thank you.
All right. Sorry, Miss Bridgewater, we're ready to go now.
Sorry, everyone.
Thank you. So I think pre-trial, I'm not sure.
As she left us, she probably like, I
I
don't want to hear that.
I still see
I'm
her.
here.
We talked about you, Ms. Roberts. We'll take it back. You're still with us. Go ahead and give us the history, please, ma'am.
Yes.
Okay.
He has one side, this is called quick, right?
Yes.
Yes.
One cycle from 2013 for simple battery. I didn't see a disposition. Sorry, about the baby.
Mhm. And that's it? Oh.
Okay.
Okay.
In this case, the law enforcement officer were dispatched to the Waffle House located at 3319 Old Milton Parkway. There were several calls alerted to 911 regarding the defendant. He had pulled out his genitals and exposed it to the customers within the store. One of the callers, her name was Rachel Bodeck, Bodeck. She was there dining with her juvenile niece, so she was concerned about the safety of her and her niece at that time. The officer spoke to the other patrons and I believe the manager within the restaurant, and the defendant was arrested for public indecency. The state is asking for a stay away from that location, no further contact with Miss Rachel Bodeck, and a $3,000 surety bond to the one count of public indecency.
Okay. All right, PD admin.
Thank you, Your Honor. And just to clarify, there were two locations on there. It was the Whole Foods and the Waffle House. So are you asking for a stay away from both?
Well, I can ask for a second stay away too.
I was just asking.
I only asked, I think he ended up being arrested at the Waffle House. I only asked for the Waffle House, but I think there was two sightings.
I just saw the Waffle House, so I don't.
One.
I was just asking for Waffle House.
Wanted to
Okay.
clarify, hoping I didn't
Yeah.
miss anything.
No, you're good.
Anyway, my client is 29 years old. He graduated from high school, and he's lived in Georgia his whole life. He has strong ties to the community, Your Honor. He's currently actively looking for work. He's been submitting a lot of applications, just waiting to hear back. So his indigency is a concern, Your Honor. He cannot afford any bond today. He does not know the complaining witness. It's my understanding he already was told to not return to the location. He does not object to that. It's my understanding he doesn't even live near there. That won't be an issue. And so I am requesting a signature bond, Your Honor, as he cannot afford any bond set at this time.
Okay. I'm going to and let me ask this, and I don't know if I heard this or didn't hear it. What about family, relatives, ties, or anything? Even is he residentially challenged as well as unemployed, both, or just?
No, he's not residentially challenged. He is, it's my understanding he's living with his mom. I have her phone number and her address. It's in Alpharetta.
Okay. All right, I don't think he has his hand up, but let me give my ruling.
Okay.
Then let's see.
It looks like he may, but I can speak with him
it looks
after.
like he does. I don't know if what you're going to say, Mr. Colquitt, is going to be helpful for my ruling, but let me do that first. And then if you have a question about your bond conditions, maybe we can answer it, maybe not. You have to talk to your attorney, okay? All right. I'm going to order the $3,000 surety bond. And with the surety bond, obviously there's going to be a stay away from the Waffle House on Old Milton Parkway. There will be no, actually, I was getting ready to say all of the Waffle Houses in Fulton County, but that may be, I don't know how many there are, but just certainly in that Milton Parkway, Alpharetta area, and I'm at least do that. So it's not just the Milton Parkway location, Mr. Colquitt, it's any that are in the Alpharetta area. Stay away from all those Waffle Houses. It still could be quite a few. You are to have no drugs, alcohol, weapons, or guns while on bond. You're to have no further contact with the victim or any employees of the Waffle House. No contact with them. And I think that's all I order at this time. Anything else? I leave out anything?
No, that is all from the defense, Your Honor.
All right, thank you.
And who should I send the consent order to for the person who's going to pad?
Ms. Bridgewater.
Okay, thank you. I'm gonna send that to you now.
Judge, I do have a quick announcement.
Yes.
Position 12 waived their appearance. And also position 14, bonds been paid.
Okay. And 14 bonded out. I thought I had one more. Let's see.
Oh, and then also, but that one was also, that was actually no cross. That was position 13. They waived their appearance, but it's no cross anyways.
Okay. Oh, I had a no price. Yeah, that was the other one. Okay, I think we're good. Thank you so much.
Just real quick, for
Yes.
position 19, Mr. Vito, he was requesting Ms. Kim to go back to his case. So I was wondering, are we complete with that?
Actually, Your Honor, he and I have had long discussion about the condition. First of all, he wants to put it on the record that complaining witness, her name is a fake name, a false name. Her real name is Alicia Johns, not Alicia Grace. And Alicia is also spelled with Y instead of I. And it's very important. He believes that she does not want to talk on the screen because she knows she used a fake name. He claims that all the allegations that she was making is not true. He denies the allegation. We want to put that on the record. And because of his medical condition, where he recently had a car accident. He's very sick. We want to make sure he can be sent to Grady Hospital for medical checkup.
I don't know that the victim's name is going to prevent him from receiving medical care if he needs it while in the jail. That's what you're saying?
No, Your Honor. We just want to put that in the record. So he wants to press charge against Alicia Jones, who made a false report and gave false name to the officer.
I'll get right on it, Ms. Kim.
Thank you.
Thank you,
Yes.
Mr. Walker. All right.
Mr. Walker.
Thank you, Mr. Walker.
Ah,
We needed that laugh.
thank you.
On
We
a
did.
Monday.
Thank you.
Fulton County doesn't recognize this holiday anymore, right? I think they took it away for Juneteenth or something.
Mm-hmm.
They did, yeah, they took it. All right, anything else before Miss Bridgewater?
I think we're gonna do
We gotta do the one, I'm sorry, the waiver, don't we?
yes.
I'm sorry.
Your Honor, what happened to the case for Mr. Sandhe, Sandhe? The last name was S-A-N.
Oh, that what, I had bonded out. She said.
Okay.
Yeah, they just said he bonded.
That was, okay, got it.
What position was that?
14.
14, yeah, we got that.
Okay, got it.
All
Thank
right,
you.
so this is 23 CR 006-064F. Demario Moss, charged with
Yes.
1 count of driving, hit and run. January 31st, pretrial.
15 cycles. Last arrest was September of this year for armed robbery, ag assault, robbery, and possession of a firearm during the commission of a felony. That's an open case, 23 CP 221802. On FTA 2016, driving while license suspended or revoked conviction 2011, a reckless conduct conviction 2009, and then a 2006 conviction for willful obstruction, possession of marijuana less than an ounce, and carrying a pistol without a license. And nothing further.
All right, thank you. State.
Your Honor, this incident took place on I-20 westbound, near Fulton Industrial Boulevard in Atlanta. The victim in this case, her name is LaTonya, that's L-A-T-O-N-Y-A, last name is Jennings. She called officers to report a hit and run. The victim stated that traffic was slowing and going to a stop when she was suddenly struck in the rear by a vehicle that was later determined to have been driven by the defendant. Of course, based on the charge, this defendant did leave the scene. And again, there was an investigation conducted to determine that it was the defendant who drove the vehicle, and that was by the victim taking a picture of the tag, and it was later determined to be him. The state's recommendation in this case, I'm sorry, 1 second, is a $5,000 surety bond, no contact with the victim, no drugs, alcohol, or weapons. And Your Honor, this defendant, I just want to point out, he does have an extensive driving history. I do have a 2021 FTA, 2020 FTA. There are FTAs from 2011 and 2012, and you've also heard the criminal history as well. So that is the recommendation for the state.
And let me ask, because I don't have this on my calendar anymore. What was the arrest date? Or because it is January and we're in October. Sometimes, you know, I used to have that on the calendar, so I would kind of know that they've only been in there a day or two, or they've been in there a long time on some other charges. What is the arrest date?
Sorry, one moment.
Okay.
Your Honor, what I have is actually September 12th, 2023. And the warrant was actually issued on October 3, 2023. I believe this is a Riverside issue. He's been in the jail for a long time, but this just got brought up now, even after the warrant was issued on October 3.
Look at that, Miss. sorry, or Ian, Mr. Walker, rather?
I'm taking a look, Your Honor.
Okay.
Mr. Walker, do you have it?
I just pulled up the gelling screen, but you go ahead if you have it.
Well, from what I can see, he's being held on felony charges as well. And it does appear that this hit and run shows that he was confined from September 12th of 2023.
But he wasn't, I'm looking at it, says he wasn't booked in on this charge until October the 7th.
Okay.
Oh, is it saying October 7th is the
And when you
booking
click
date?
on the actual charges, he was booked in on this particular warrant, October the 7th.
And it was issued, well, 10-3 and then booked on 10-7. Is that what we have? Or where did PD Kim was saying 10-3 for the warrant?
So I thought
Hey,
he
we
was
could do a
booked
signature
on.
by, it's not a Riverside issue because he wasn't booked in on this charge to the 7th. He has more serious felony cases with no bond. So
That
I
is
don't
not
have
going
an issue.
anywhere anyway.
Yes, I don't have an
Yeah,
issue.
but I was concerned if PD Kim was correct that the warrant, well, 10-3, but then, and I thought that was going to be the date, but if it's not till 10-7, then you're right, it's not Riverside.
Right. So, I mean,
So are you saying that he was booked on September 12th and then he got released meanwhile, and then he was booked on again on October 7th? When was he released?
he wasn't booked in on this charge in September. He was booked in on this charge October the 7th.
Oh, okay.
Right,
So
he was
pull up
booked
the
in
gelling screen and then
felonies.
click on the charges tab. It'll tell you what day he was booked in on each charge. He was
Mhm.
booked in on the felonies on September the 12th.
Gotcha.
Got it.
Okay. And so the state's recommendation is a $5,000 surety bond, but he has no bond on his felonies.
Right, Your Honor. And then Mr. Walker said he would not mind signature on bond for this case. So we would like to recommend for signature on bond.
Is that correct,
fine.
Mr. Walker?
That's fine. That's fine.
Okay.
He's not going
All right.
anywhere. He has like 5 felonies with no bond. So
Okay. All right. We'll do a $5,000 signature bond through the jail.
I will say this: if he's not going to get out, so he's going to be on SAP. Now, when he goes to SAP and he only has 24 hours served, I don't know if that will be in his favor. I don't know if he wants to enter a plea, but if he ever wants to enter a plea, just know he's only going to have 24 hours going towards this particular charge. He's not going to have the time from the felonies because he's getting a signature bond. So, I mean, you can pick which one you want.
Yeah,
We
you tell me,
understand that
Kim.
we still would like to choose for signature on bond through jail.
Okay.
Thanks.
All right. I will do that. No drugs, alcohol, or weapons while on bond. And do we have a stay away as well?
No, Judge, but a no contact.
No further contact with LaTanya Jennings. Okay. And I think that's it, Ms. Bridgewater.
Okay. If you all are ready, I am.
Thank you.
Okay, once again, the reset date for the SAP calendar is October the 24th. Position number 1 is going to the SAP calendar with a total $6,500 good bond. Position 2 is reset further notice with a $1,000 SOB through the jail. Position 3, SAP calendar with a $3,000 good bond. Position 4, reset further notice with a total $4,000 SOB through the jail. Position 5, reset further notice with a total $2,000 SOB through pretrial. Position 6, reset further notice with a $1,000 SOB through the jail. 7, SAP calendar with a $5,000 good bond. 8, SAP, $3,000 good bond. 9 is reset further notice with a $5,000 SOB through pretrial. 10, reset further notice with a total $5,500 SOB through the jail. 11, reset further notice with a $2,000 SOB through the jail. 12, reset further notice with a $5,000 SOB through the jail. 13 was null pros. 14 was released, therefore it's being reset further notice. 15, reset further notice with a $2,000 SOB through pretrial. 16, reset further notice with a $3,000 SOB through pretrial per judge. 17, reset further notice with a total $11,000 SOB through pretrial per judge. 18, SAP calendar with a total $11,000 good bond. 19 is going to the SAP calendar with a $3,000 good bond. 20, going to the SAP calendar with a total $4,000 good bond. Add on 1, SAP calendar with a $3,000 total good bond. Position number 2, SAP calendar with a $6,500 good bond. And position number 3 is reset further notice with a $3,000 SOB through pretrial. Are there any questions, comments, or otherwise?
You can breathe. It's good.
I have a question.
Sure.
Did you get the co-signer name for position 17? I can't remember when I wrote it down.
It was, I'll tell you, it was Veronica Reese.
REESE, right?
And that was his grandmother?
Yes.
Okay, thank you.
No worries.
Grandmother.
Anything else? I'm scared to say.
Don't ask.
Okay, okay. Bye, y'all.
Thanks, y'all. Have a